Hello, hello, hello. This is Attorney Mike Gravel coming to you from Chicago as usual. And today you're in danger of actually learning something. I've got, let me see here. Let's do this. I've got Kurt from Uncivil Law. Say hello, Kurt.
Hello, how are you?
All right. So today we're going to tackle the House bill recently signed, apparently, into law in Arizona. Mm-hmm. The basics are you cannot videotape police activity within 8 feet. Mm-hmm. So I got a lot of questions from my viewers about this. Have you done a video on this, Kurt?
I have, as a matter of fact, yes.
You have?
Mm-hmm.
I missed that. So you're prepped and ready to roll.
Oh, yeah. I have thoughts. These thoughts may or may not please people, but I'll give them as best as I can.
All right. You sound a little low here to me here. Let me see here.
All right.
No. How do I adjust your mic? Turn yourself up a little bit.
All right. I'll see what I can do here. Let's see. It's going to be on audio. Hold on. I know what to do this somewhere. Oh, yeah. Automatically adjust. Let's see if that does anything for us. Is that better?
Worse? Yeah. It sounds a little better.
All right.
Maybe I just need to turn up here. All right. So what we're going to do here, I have to do this. We'll do our little intro. Okay. So what I'm going to do in preparation for this, I'm very proud of myself. I actually read the bill.
Excellent.
It's one page.
It wasn't very long. That's true.
So I'm gonna attempt to do that now, just so that everybody's on the same page here. Okay. So let's grab that. Here it is. It is unlawful for a person to knowingly make a video recording of law enforcement activity if the person making the video recording is within 8 feet to where the person knows or reasonably should know that the law enforcement activity is occurring, either receives or has previously received a verbal warning from a law enforcement officer that the person is prohibited from making a video recording of law enforcement activity within 8 feet of the activity and continues to make a video recording of the law enforcement activity within 8 feet of the activity. If the law enforcement activity is occurring in an enclosed structure that is on private property, a person who is authorized to be on the private property may make a video recording of the activity from an adjacent room or area that is less than 8 feet away from where the activity is occurring, unless the law enforcement officer determines that the person is interfering in the law enforcement activity or that it is not safe to be in the area and orders the person to leave. Okay, that's about half of it right there. And that's what I thought the whole law was. And based on that alone, I thought, no way. That just gut reaction. I'm not even giving a basis. I just gut reaction from taking con law, as I told you, 73 years ago, and then brushing myself up on it 2 years later to eke by the bar exam. I just looked at that and said, no, that doesn't work. But as we go forward, it gets more constitutional, shall we say, if you ask me. Because there's one burning question there. One burning question, I thought, does the suspect get to do this, or is this aimed at other parties? And we get there. Notwithstanding subsection A of this section, a person who is the subject of police contact may record the encounter if the person is not interfering with lawful police actions, including searching, handcuffing, or administering a field sobriety test. The occupants of a vehicle that is subject of a police stop may record the encounter if the occupants are not interfering with lawful police actions. This section does not establish a right or authorize any person to make a video recording of law enforcement activity. A violation of this section is a class 3 misdemeanor. So it's not a heavy penalty. Okay. I'm guessing class 3 is low level. I don't know. I'm not familiar with the code in Arizona, but that's just my guess. For the purposes of this section, law enforcement activity means any of the following: questioning a person, conducting an arrest, issuing summons or enforcing the law, handling an emotionally disturbed or disorderly person who is exhibiting abnormal behavior.
Mm-hmm.
That's it. That's the law.
Mm-hmm. Yeah.
So what do you think?
Well, okay. So we can get into the specifics of problems with the law, but I think what people really want to know is if the overall broad principle of the law, regardless of its technical aspects, which obviously could create technical problems, but people really want to know, is the law in sort of its conception unconstitutional? And I think the answer is almost certainly no. The issue here is that this appears to be a content neutral time, place, manner regulation. Right. So under First Amendment law, you have to determine first if it's a content-based regulation or a content-neutral regulation. If it's a content-based regulation, that is, we're trying to restrict the speaker as to what kind of particular content they are recording, then it's content-based regulation. If, however, we're content-neutral, then we are under intermediate scrutiny. And the case on point for that is Ward versus Rock against racism in 1989. The principal inquiry in determining content neutrality in speech cases generally, and in time, place, or manner cases in particular, is whether the government has adopted a regulation of speech because of disagreement with the message it conveys. Are they trying to get to the message, that is the subject matter, or are they trying to do a content-based regulation? Now, I think this is almost certainly a content-neutral regulation. I will take note, of course, the statute by its own terms talks about law enforcement activity. So one might argue that this is on content-based because it's only prohibiting being 8 feet within the space of law enforcement activity, and therefore it's content-based. However, I think this argument is probably wrong, and it's probably wrong in light of a case that actually came out earlier this year, April 2022, City of Austin versus Reagan National Advertising, ironically enough. In this case, the City of Austin banned billboards. They banned electronic billboards, more precisely, that were not relating to the business. That weren't on a business premises. So you could have an electronic billboard if it was on the business premises of the business, but you couldn't if it was off premise. All right. So the question was, this is content-based or content neutral? The Fifth Circuit ruled, and I thought made a pretty reasonable argument, that this was a content-based regulation because you can't know whether a sign is on premise or off premise without looking at it. Right? Because whether it's on premise or off premise depends on the message of the sign. Right? If it's a bank and the message on the billboard is about the bank, it's an on-premise sign. But if the message on the billboard that's at the bank suddenly is about something other than the bank, now is it an off-premise sign? So you can't determine if it's on-premise or off-premise without reading it, at which point you're in content-based. The U.S. Supreme Court disagrees. The U.S. Supreme Court determines that looking at the sign in order to determine whether it is commercial speech or not is insufficient to determine whether it is content-based regulation. So I think in light of this, right, it's the same sort of logic as in City of Austin. Right, we're trying to determine whether this speech is content-based or content neutral. We have to determine whether it's law enforcement speech. In some sense, we can't do that without looking at it. So the Fifth Circuit would have said that's a problem. The U.S. Supreme Court says no. We can look at it to determine, we can look at it for the purposes of determining the boundary lines, because we have to know 8 feet from where, right? We have to know where we're measuring from. And so right. in order to know where we're measuring from, we have to look at the thing. But that is insufficient to turn into a content-based regulation. So it doesn't matter, incidentally, and the reason also it's not content-based, in my view, is because it doesn't try or even attempt to say, that it depends what your viewpoint of the police are or what you're trying to do. It's not like if you're pro-police or anti-police. The fact that it doesn't have carve-outs for the media in some sense is probably helpful and towards the regulation. Because it's not like, because the issue, if it had a carve out for the media, would be like, well, who determines who the media is? It's usually the agency. It's usually the police department. And so now
it's another hot button that we're always dealing with.
Right. So if it had a carve out for the media, it's like, well, who determines who that is? It's usually the agency. So it's the police department. And the police department is the one handing out the media passes. Well, who do you think they're handing out the media passes to? Their favorite people, right? So suddenly we're picking and choosing based on viewpoint. So the fact that it doesn't have a carve out for media is actually helpful to upholding its constitutionality. So I think in light of I think in light of Ward and in light of City of Austin, this is a content neutral time, place, manner regulation, at least in principle. And then again, as to the specific text, we can get there. So if we are under intermediate scrutiny, we need to show two things. We need to show that there's a substantial governmental interest, and we need to show it's narrowly tailored. Narrowly tailored is where we're going to run into problems on the actual text of the law, but we're still dealing with principle. All right. So does the government have a substantial reason, right? It's more than legitimate, but less than compelling. Is it a substantial reason for there to be an exclusion? Yes. Why? I mean, it's not too hard to think of a reason, right? Safety is the obvious one. It's an obvious go-to, right? If they're within 8 feet, they're at risk of being grappled or hit or a suspect hitting them or whatever. They're within a zone of danger. It's a reasonable approximation of a zone of danger. And if you're looking for support for 8 feet in particular, I would ironically support the abortion case coming out of Colorado in 2000, which dealt with buffer zones at abortion clinics, which was exactly 8 feet, ironically enough, that upheld that 8 feet was an okay distance. If you're wondering where 8 feet came from,
it may not have been lost on the drafters of this.
Yeah, if you're looking for where 8 feet came from, yeah, that's the Colorado case dealing with abortion clinics buffer zones in 2000, where 8 feet came into play. Because it's a normal conversational distance, it's okay. Anyways, so where was I in this analysis? Oh yes, so we're trying to show a substantial governmental interest. It's like, okay, well, we're within some zone of proximate danger. If there's a police activity ongoing, there's a risk of danger, and we're trying to exclude them. Also, on just a practical level, the fact that you're like inside their face is presenting a bit of an issue for the police actually able to undergo. Like if you're right up on top of them, obviously their movements are restricted and they're more problematic. So like, okay, so is there a substantial governmental interest? I think you're checking the mark. All right, and then we get into the aspect of narrowly tailored, which is where the law might run into trouble, because we have to, in order to do this, especially in a criminal context, because the criminal law is to be narrowly construed. If we are to do a criminal statute, we have to make sure that the statute is clear as to what's illegal, and it has to be done with sufficient specificity to avoid a vagueness problem. And vagueness is somewhat enhanced in this context because of the narrowly tailored element of the First Amendment. So we have to not only do the normal vagueness, but we have to kind of go on top of that so that it's normally tailored to meet the First Amendment analysis. So I think there are some problems with the actual text of the statute, or the actual statute itself. While it defines what police activity is, it doesn't actually define where we're measuring from exactly, because it talks about, like, for example, a police officer interviewing a suspicious person. First of all, how are you supposed to know if the police is interviewing a suspicious person? How are you supposed to know that as opposed to a witness or anyone else? How are you supposed to know? But second of all, even if you could know, 8 feet from where? 8 feet from the witness, 8 feet from the police officers questioning them, 8 feet from somewhere in the middle, 8 feet from the police cruiser that's on the sidewalk, 8 feet from where exactly is a little bit unspecified. So there's that problem. Also, the fact that 8 feet
close to that is also the complete discretion given to officers in terms of warnings and their.
The fact that you have to give a warning is helpful to the statutes because it's like how the person is supposed to know if they're in 8 feet. So they're put on actual notice. Of course, it's actual notice of what the police say 8 feet is, which is a whole nurse.
But it's completely subjective, and it's entirely within the police officer's discretion, and I would attack that if I was trying to take this out.
To some degree that's true, but to some degree it's not. And the go-to here, I can just point out that, like, for speeding, while it's certainly helpful to have radar detector, there's nothing strictly speaking requiring it. Like if you have a speed limit that's like 5 miles an hour, and a cop pulls you over and you say, well, how'd you determine? It's like, I looked at you and you looked like you were going 15. Like, that's perfectly valid testimony. Right now, we can question that for a whole bunch of reasons. Like, how were you able to determine it on your experience or whatever? Like, how did you make the determination? But like the idea that a police officer has to determine, like, from his own visual, like if you're going past, and obviously, or maybe not obviously, but if you're going 6 miles an hour, it's in violation of a 5 mile an hour speed limit. And so if the police officer is somehow able to determine you're going 6 instead of 5, so then it just becomes an issue of can they make the determination or not within the bounds of a criminal statute, which requires proof beyond a reasonable doubt amongst a whole bunch of other things. but like at least in principle, like it kind of makes sense. So yeah, there's the other problem that I noticed is that it becomes a roving zone, which is consistent with the Colorado case dealing with the buffer zones. Although the buffer zones, I don't think had a criminal penalty. So the fact that it's a criminal penalty does make things more interesting, because the fact of police activity is not static, right? It's not like it's going to be where it is for any length of time. It's probably going to move. If a police officer is trying to tangle with a suspect, this is a dynamic situation. And so then I'm just back to 8 feet from where exactly becomes a problem. And can the police officer, by their actions, close the distance? So if there's no particular reason for them to move closer to me, can they, for the purpose of closing the distance of the 8 feet, and then give me a warning just to interfere with me? Or
right.
is that
or
like
can you just have your partner walk them off? Yeah. And say, what I mean? While you're questioning the suspect, you have your partner walk close to him and just push him back by 8 feet, 8 feet, 8 feet. You'll have this stuff will come up.
Yeah. So there's some problems with the way the statute is defined, and also on a very technical reading, the way the statute's written kind of eats itself. And I'm not sure if a judge would interpret this way, because it says, a person who is the subject of police contact may record the encounter if the person is not interfering with lawful police actions. Okay, let me tell you how the statute just ate itself. What does it mean for a person who's subject to police contact? Now, you probably thought to yourself, a suspect, or a witness being interviewed. But remember what the statute said? The statute said, in order for you to be guilty of this, an officer has to give you a verbal warning, right? If an officer is giving you a verbal warning, are you now a subject of police contact? So the statute actually is completely moot on its face. I mean, there's an arguable error there. Like, the statute eats itself.
Right.
I mean, so, and again, while one principle of law is we try to avoid reading statutes in conflict with itself, or for that matter, other statutes, the criminal law is to be narrowly construed. So the fact that it's eating itself creates problems in a criminal context. This is where civil, I wouldn't have such a problem, but there are some issues. So those are some of the issues I spotted. How am I doing?
That's pretty darn impressive, I have to say. Yeah. I have a couple. First of all, I read like one article, I think it was NPR or whatever. They cite an ACLU attorney who says that it is not content neutral. And of course, right. But you expect that. I mean, the ACLU is not doing their job if they go along with this.
No.
I mean, that's their raison d'etre.
And like, it's not a frivolous argument. It just seems to fly a little bit in the face of Austin, which was in a different context, to be fair. But it still flies a little bit in the face of the context, because, like, yes, it's prohibiting you from recording law enforcement activities as some other kind of activity. So in that sense, obviously, it's related to particular kinds of content. We don't want you recording police activity. We don't have a particular problem with other kinds of activity. Is that content based? Well, if I have to look at the sign in order to determine if it's a commercial advertisement, but now I'm looking at the sign and reading it is not content based, then I think the better reading is probably that it's just simply defining the zone, and the fact that I have to look at it to determine what it is not sufficient to be content based. In light of
all right, my other question:
City of Austin versus Reagan.
I don't like have a specific reason for this, but other than, and you're going to hurt my brain right now, but why do you say intermediate scrutiny as opposed to strict scrutiny? I mean, you've got a potential First Amendment violation. My first thought is strict scrutiny, compelling purpose, narrowly tailored.
Yeah. Well, the fact is that if you're dealing with a time, place, manner restriction, that's just classic intermediate scrutiny. And okay. So, like, you can look to Ward versus Rock Against Racism as a good case on that point, or you could look to, I have somewhere in my notes here. Hold on. I had marked another case that was kind of on point.
Fair enough. This is truly impressive.
Yeah, Ward versus Rock Against Racism is probably your point. That it has to be, the regulation is not because of disagreement with the message or a subject matter. It's for other reasons. And those reasons are not pretextual. Like, so the government could try to claim, well, it's really for this reason, but it's really not. So, like, you could, if the government came up with a pretext reason, you could look past it. But I think, like, I don't think you can get past the pretext. Assuming it is a pretext, I don't think
you get me convinced.
Like, there are in fact actual safety concerns. If that's their stated concern, I don't think you can get past it. It's just an opinion.
Very interesting. My gut on this was no way. But I'm coming around to it. You know what? By the way, it's sort of a codification of what's really going on right now. Anyway, out there, they all already are saying we have a scene. You need to back up.
Yeah, and also, of course, the abortion case from 2000 was also an 8-foot zone. In that case, and incidentally, when it comes to the abortion cases, which makes the fact that the zone is somewhat open, in the abortion cases, like dealing with the bubbles or dealing with the keep back distances. And incidentally, this also has been applied to voting locations. If you want another context where these kinds of buffer zones have been upheld, it has to be like, it can't be like 100 feet from, it has to be like, so many feet from a person in interest. So like from a voter or something like that, the way it's usually defined, or from a woman going in to seek the abortion, or in this case, the officer. So there is some elements that help to support the city. So it's not like inherently absurd what they're trying to do.
Right.
At least in my view.
It's interesting. I have interest in this like I told you, I had viewers asking me about this. So I really appreciate you coming on and discussing it, because you know a lot more about it than I do. But I told people they weren't necessarily going to like my answer, but I tried to give the best answer. Well, it's interesting. No, some of them will, because a lot of this comes in through the context. I do like First Amendment auditors. I don't know if you're familiar with that, where they go and provoke things on purpose. Okay. So, you see a lot of that stuff. And this has been my biggest thing, because I'm a bit of a civil libertarian myself. And when they keep pressing this, and this is clearly designed for that scenario, that's what it is. But you keep pressing that, you're going to erode freedom. They would just leave it out there. But if they have auditors on the daily, videoing their traffic stops, which is what they have, you're going to have this sort of reaction. I lost Kurt. I think he'll come back on. All right. Why don't we do this here? I'm going to take a look at this. So it's interesting that Kurt said that here we are. Here's the attorney from the ACLU. Quote, "There is zero evidence in the record that the law actually addresses a problem," said K.M. Bell, an attorney for the ACLU of Arizona. "We are investigating all possible options for addressing this unconstitutional law." Bell said there were several specific problems with the law, including that it was overly broad. It limits what people can do on their phones while near a police officer, which amounts to a First Amendment violation, Bell said. "This is a content-based restriction, because I can stand 3 feet from an officer and play Angry Birds, but I can't stand three feet away and record them," Bell said.
Yeah, you can't really do that either. If we're engaged in police activity, well, it might not be criminal because you're not videotaping, but like they can definitely ask you to move. And incidentally, like,
I don't really like
the
that.
idea of the police asking you to leave a place that you otherwise have the right to be in the interest of safety has been done in all kinds of contexts. I mean, in certain situations, entire city blocks have been cleared because of a sufficient threat. They're searching for, a whatever bomb or something like that. And like, yeah, depending on the nature of the threat, yeah, they can get you to leave the place. Sometimes for quite some distance, depending on the nature of what they're trying to do. It has to be justifiable, but you can get there.
I wasn't really buying the Angry Birds distinction either. No. I mean, it's
also I'm not sure playing Angry Birds is a protected First Amendment activity with all the possible.
Well, it's not a matter of your choices on your phone. It's in the content. What they're worried about content based is, are they doing this for political reasons? That's the fear that we're going after. Are we going to be applying this to these people but not these people? For political reasons, to harass, and that's the government overstep that the Supreme Court is going to be afraid of.
You're going to have a tough time with that unless you can show that they're overtly discrimination on the basis of race or something.
Right. But I think that's the content discrimination that he's sort of conflating with the Angry Birds. Which app do I use on my phone?
Yeah.
So,
Yeah.
that's.
I mean, there are definitely areas of the statute which provide problems and provide areas that need to be interpreted. And so the idea that the statute on a facial challenge, I'm not 100% sure about a facial challenge, but on as applied, yeah, maybe, because there's some potential problems here because of the criminal law context. So, but like the principal idea that they can require you to be some reasonable distance, and I know it's a dangerous word, but away from the center of the police activity in the interest of, maintaining the scene, their officer's safety, the safety of the suspect, your safety, any number of other reasons. It's like, yeah, it's probably not safe to be right in the middle of the conflagration. So asking you to like back up a little bit. Yeah. And there's endless law kind of dealing with that. So I think in principle, and if you are going to make it a crime, I mean, you have to define the crime with specificity. So you're going to have to say, some number of feet is actually a nice idea, because like, what's your alternative? Like, you can't be too close to the officer that would interfere with it. It's like, what the hell is that?
Yeah, that's too vague.
So 8 feet is actually kind of nice for that reason.
Like I said, my first reaction to this was not no, but hell no. This is not going to stand up. But my biggest, the thing that stuck out to me most is, what about a defendant who wants to record it to protect their own interests? Mm-hmm. And when they cut that out and said the defendant themselves can do it, or the suspect, however you want to put, they're not a defendant yet. They don't have a charge.
The person who's engaged with the police activity. Yeah.
Yeah, once you cut that out of there, and then I think another compelling argument is, hey, if you want to do this, 8 feet is not bad. I mean, you want to, you're 10 feet away and you've got your phone, you can get a good view of what's going on.
Yeah. I mean, yeah, with 1080 or 4K, I mean, 10 feet's a very reasonable distance.
All right, where do you think this plays out? I mean, everyone thinks Supreme Court immediately, which obviously it implies Supreme Court. But I think this this may get decided in the Arizona Appellate Court.
Yeah, I think it's probably right. I think
not even the Arizona Supreme Court. I mean, it could go back and forth. Obviously, it could go up to the Supreme Court. But I think you got to start this one in the Arizona Appellate Court.
Yeah, so the burden is on the government to prove the substantial governmental interest. So they do have to prove it. And the law as written didn't contain any like reasons, did it? Or the other things, it just contained the law? Did it contain like reasons we're doing this? That'd be helpful, like findings? Nothing like that? So are we having to guess? Because that's a problem. If we're going to like prove this, we have to like prove this with some sort of like, actual way of getting there.
Okay.
If we're doing rational basis, we wouldn't have this problem, because any reason will do. And it doesn't even have to be a reason the legislature contemplated. But if we're doing intermediate scrutiny, which is like our bare minimum, and we're having to find a compelling governmental interest, it's like, well, what is it exactly, legislature? And now if they had just said the safety of, they said any version of public safety, they're almost certainly there. Because I think they're there. I don't think
so.
You
make a compelling argument for the constitutionality of this. However,
at least in principle, on the
exact
text of it,
But you're also an attorney, and you're also a big devil's advocate. So
sure.
We're going to close this thing out. First of all, thank you very much for coming by. Everybody, go over to subscribe to Uncivil Law. He has lots of cool stuff. Mm-hmm. Okay,
yes.
But we have to leave this with. I get it, and you made fantastic argument and cited actual Supreme Court cases, which I guarantee you I've never read. Do you think this holds up or not in reality?
I think on first blush, yes. I think maybe with closer inspection, I don't think it's a gimme. I don't think we're going to be able to get an injunction tomorrow. I think I don't think it's see. I don't. Yeah, I would tend to think the government is marginally favored in this, at least on first blush.
Awesome, John. How you doing, buddy?
I'm doing all right. How are you guys doing?
Good. Nice to see you.
John is here to completely contradict everything I just said.
Hey, were you watching any of this? No, that was impressive, Kurt. Honestly, yeah. I mean, you're citing cases, and it sounds like you actually read them.
No, it was a really good analysis. I tend to agree on the intermediate scrutiny. I don't necessarily agree in terms of what's actually been established.
You might well be right.
And
I mean,
so
it's not like
that,
it's like not like a strong position. I think I was like not like giving strong indications. Yeah, this could be. I mean, if you want to go the other way, it's totally understandable.
Yeah, no, I mean, my thought at the end of the day is that I agree with the standard scrutiny. Unfortunately, I actually disagree with intermediate scrutiny as a principle, but I think we probably agree on that one.
Right.
It seems like a wishy-washy way of getting out of actually dealing with tough problems.
Well, yeah, heaven forbid we start looking at it too much and we start talking about rationality plus and rationality minus and intermediate scrutiny plus and just kind of
God
weird
forbid
things.
we actually address substantive due process, but that's probably not in the cards these days. No, I think I was listening to the conversation. I actually think that the law as written cannot stand, but the reason is purely unconstitutional for vagueness.
Yeah, fair enough.
Outside of that, I don't think that there's a good reason to strike it down. I think that if it were written without the vagaries, that it actually would stand constitutional muster.
Yeah,
So
and if this were any other criminal law, I wouldn't say vagueness. But the fact that we're in a First Amendment context and now suddenly we have to do narrowly tailored on top, your argument is well founded.
So that's where I kind of came at it. Was it just, again, void for vagueness, because all the things that you said, Kurt, in your video and what you said this evening, absolutely 100% correct. There is not enough clarity in terms of what is and is not within the bounds of the constitutional structure, and they don't have a way of solving that.
Well, it's interesting because you don't know how to draft it from their perspective. They might even be onto this, like, hey, it'll probably get struck down, but maybe, and you don't know because you do not know with these appellate courts or the Supreme Court. Maybe they'll say this is unconstitutional. You can't do it, or maybe they'll say it's unconstitutional, but it would be constitutional if you did it like this. Then you just redraft it and do it, but you don't know if you get those breadcrumbs or not.
Well, and that's one of the things that I actually really hate about bad draftsmanship in law, is that in the interim, because Supreme Court only takes 80 to 120 cases a year.
People take like 60 something this year. Damn assholes. You could take some actual cases.
But how long are people suffering in the limbo in the meantime that might get, clocked with what ultimately becomes an unconstitutional statute? Like, that is actually something that should be concerning to us, and we should demand more of our legislators to draft clean and clear laws.
I don't know. I think it's probably true that the statute was envisioned to deal with a very specific problem, and it's probably substantially more likely than not that when this law gets applied, it's going to be against a real asshole. And you know how the courts like to deal with the real assholes. It's like, we're going to look past a lot of issues to punish the asshole. It's going to be some First Amendment auditor who has a complete entitlement issue, who's just absolutely up in everyone's face and being a complete jackass
type of guy, right?
He's going to be a complete jackass, and the courts are not going to care because I want to punish this guy too bad.
Isn't that literally just proving the adage that bad cases make bad law?
Yeah,
mm-hmm.
Yeah.
Mm-hmm.
I mean, do you think that it's literally just bait for these people, or? I mean, I can't imagine a court just
don't be a total asshole.
I get what you're saying.
Don't be a total asshole goes a long way, right? I mean, is it really too much to ask the police to give them some minimum distance so that they can actually do their job? I mean, you can.
In defense of the drafters of this, I will say this: if we got assigned this, if we're at a firm and somebody assigns us, hey, draft this legislation,
I think I can. Okay? Make some.
This is a good stab at it.
It's not a bad stab. No, let's make some.
I think between the three of us, we
did try to tailor it. Oops.
I think between the three of us, we could probably do a better job.
Well, they gave a good try. I mean, they certainly thought of a lot of things. The 8-foot zone being defined was nice. And that they find police activity at least somewhat was nice. They could have been a little bit more clear about that. And the way that the law technically eats itself is kind of hilarious. But yeah.
I did not even think of that. That was a good point. You brought that up, though. Because once they warn you, you're subject, and you know that argument's coming first thing. The first person who gets prosecuted is going to say it.
No, probably not the first person, because it's probably not be the first thing that occurs to some attorney, but someone will think of it. Maybe they'll watch this video and they'll know.
Well, I mean, I think even something as simple as, if you put into a definition section what defines the locus of the police event.
That would be helpful. That'd be great. Yeah.
There's a way to draft a definition section in such a way that it doesn't catch people off guard. So I think, Kurt, you made a great example. What if the suspect starts fleeing? Are all the bystanders who the suspect flees toward, are they suddenly caught up in this? Like, there are obvious issues to it that could be dealt with by a simple definition section.
And then also, what does it mean to be orally warned is another one. Like, do you have to be personally orally warned? Is the police officer on a bullhorn good enough? How about the police helicopter on a bullhorn? No filming within 8 feet. Is that enough? I don't know. It's like, it's a little bit vague, which goes to your point about vagueness issues.
Well, and you're never going to be able to deal with the vagueness issue. I think it'd be very difficult to deal with the vagueness issue, particularly about the warning. Although I think that that's actually a good faith attempt to try and make it constitutional.
Yeah,
but
someone tried.
I don't know how you deal with the vagueness on that aspect of it, other than if you put a reasonable person standard into the actual statute, maybe there's some way that you can do something with that.
Mm-hmm.
This is a great discussion, though, because, like I said, I've done a lot of auditor stuff. And when you do that, they're so irritating that there's a reaction. And I don't blame people. I mean, they haven't been to law school or whatever. There's a reaction. You just want to say, yeah, you know what? You can just tase them at will or whatever, like whatever draconian thing you can come up with. And while you're watching that, trust me, you want that rule. But first of all, try to draft it. Second of all, get snared in it by a nasty cop.
Mm-hmm.
Have some cop come by and you're like, I don't even know what's going on, and all of a sudden you got cuffs on. And you're like, whoa, So these things are very difficult to balance, and this law just shows that.
Yeah, it reminds me of a case one time where I'm going to get the facts of this a little bit wrong, but there was like a guy who was walking at a park with, what was it? Like, was it a rifle? But it was like technically not, like it was a toy rifle, but it was painted to look real, or like, right. So basically, like, it was not technically a violation, but he tried like really, really hard to ensnare the police officer. It was like, and basically the courts went, fuck you. It's like, it's in that specific case. I have to look that one up, see if I can find it.
Yeah.
There was something where that's like, where this guy's trying very, very hard to like create a situation which is going to fool a reasonable officer just to be a jackass. And it's like,
and that's where these auditors go. They're not too bright as a rule, but to the extent they can figure it out, they try to walk the line and make it as difficult as possible, doing exactly what you're describing.
Well, yeah. in an interesting way, and like, I am not associated with the channel in any way, but I watch Audit the Audit a lot, and Long Island Auditor, and it's interesting to see how
on my channel.
Oh, has he?
Yeah,
I find him extremely respectful, extremely.
He's pretty good.
Honest.
From what I've seen, I've seen that much, but he seems good.
I think he does relatively good work, and I don't think that that's necessarily a bad thing to hold truth to power. But you do also have the idiots.
On the details.
You end up with the sovereigns and all of that, which just becomes an absolute nightmare. So I'm kind of
sovereign citizens. Fuck them.
I'm caught between the folks that are actually out there to hold authority to account, which I think is a good thing. And also, we need to have a certain amount of
if I ever become a judge, I'm putting a sign outside my courtroom. I'm putting a sign outside my courtroom. If I ever become a judge, it says, if you claim to be a sovereign citizen, I will prove this court's jurisdiction.
Make my day.
Well, the bailiffs will probably do that for you.
And it's like, oh, you don't think contempt.
Yep.
Well, these are the messy problems of an actual free society.
They are.
I mean, if you're in a less free society, these things are quite easy. Just government has all power. That's that. It makes things quite clean, but you don't necessarily want to live in it. I mean, some people do.
Saudi Arabia is still an absolute monarchy, I believe. So you got that going for you.
Yeah.
Well, not great if you're of certain. Yeah.
All right. I think this law gets struck down, and it's just gut reaction. I'm not going to justify it.
I'll take on the bootlicking side of the argument. That's fine.
And since I am I'm the Chief Justice of the Law Talk with Mike Supreme Court. We've got 3. I think it's a 2-1 decision.
I think it's a 2-1 decision. I think it gets.
But
I don't know if the
Ninth close.
I don't know if the Ninth Circuit's going to strike it. Maybe.
We are in the Ninth Circus, aren't we?
Yeah,
we are.
Yeah, they'll. Oh yeah.
I don't see them striking it.
The ACLU said they didn't like it. It's over in the Ninth Circus. Forget it.
You really think so?
Yeah.
All right. I think it becomes the panel. We'll see on Bonk.
Well, I don't know if it even gets there. What if it gets mowed down in the Arizona Appellate Court, because that's the fastest way to go.
I don't see it losing in state court.
Stop that, April.
I just don't. I just don't see it. I don't see it in state court going down. I think that would be a little bit too much, because Arizona still has an elected judiciary.
Yeah, but they're subject to the Constitution. They can read the Constitution and say, we don't think that, whatever. It's just their opinion, but we don't think this is going to pass with the Supreme Court. We'll just go ahead and knock it out right here.
Yeah,
that is my guess.
Again, you still have the fundamental issue of, in Arizona, with everything that's been going on in the last couple of years, do you really think that a judge is going to be anti-cop in a state court? That I think that's a really rough roll of the dice.
Just film from 8 feet away. It's plenty close.
You might be right.
Just film from 8 feet away. It's plenty close. You'll be fine. I promise.
All right. Well, there you have it. Actual law talk on Law Talk. All right, you guys, thank you for coming out. I am going to do my super chats, which I was not able to handle, because I was actually having to pay attention here.
All right, I'll sign off.
Because you guys come on with like good stuff, actual thinking.
Well, you invited me on to talk about a subject. I thought I'd come prepared.
I showed up listening to what you guys were saying and thought I would try and throw a third opinion.
I was my whole thing was I sent this to Kurt, and I said, "Can you come on, because it's constitutional?" I hadn't read the law yet, and I'm like, "This law sucks. It's unconstitutional. It's not going anywhere." And then I read it, and I'm like, "No, this is better than I thought." It was 10 minutes before we started, so that was my prep on this.
Right. And John might very well be right. Like it's something that would require more consideration. But yeah, you very well might be right that this is void because of the narrowly tailored problems. So with that, I'm going to sign off for now.
All right. Thank you, Kurt. I appreciate it. Thanks. John, have you started your channel yet?
No, I haven't. I've been moving, and it's just
you're in trouble.
A million things going on in life.
All right, I won't redo it to you in this form, but you know I've been chewing you behind the scenes on Twitter.
And absolutely right. You're absolutely right about it.
You know why? Because I want to tell everyone to go over and sign up for your channel right now.
Well, I'll get there at some point. I turned 30 a week ago, and everything has just been like reorganizing life. It's one of those moments. Right. So I will get there.
I got you. Well, thank you for coming by. It was awesome.
No, it was good talking to you as well. And take care, everybody over on the chat, and take care, Mike. I appreciate having me.
All right, thank you. All right, I got some super chats here. Thank you all. Oh, by the way, I missed some super chats yesterday, and I feel really bad. I hope you're here, but there were some really nice, generous super chats as well. and I just didn't see them. And it's again because I had already on, and I apologize and try to be better about that. I don't have them here. I tried to transfer them and I couldn't. But I just want everyone to know I see them. Thank you very much. And here we have Mortimer Duke, $4.99. Constitutional or not, I find it not at all unreasonable. Yes. Whether or not a court is going to allow it is another issue. But we're talking about 8 feet, so you can still videotape this easily and get a good view. And it's excluded from the suspect. So, I mean, it really takes all my big problems out of it. What I don't like is if they're including the suspect, then you just have, okay, well, now you can't videotape and turn that off. And now we don't have all that transparency that we've had the last few years. And that I think would be a step back. And I think the courts would think so as well. Night of Knee, Law Nerds Assemble. Oh, yes. And you needed to be a real law nerd for this one. Thank you guys so much on a Saturday. I mean, that got serious. I knew it would. And thank you so much again to my guests for coming by and classing the place up here a little bit here with a real constitutional law discussion. Timmy T, $1.99 for the boys. Oh, the boys are so good. Well, not really. They're bad, but they're good. You know what I'm saying. If you have fur babies, you know exactly what I'm saying. April Searing, $1. Thank you, April. Tread, $1.99. Officer discretion is going to play big time. Yeah. This is entirely at the officer's discretion, the way that statute's written. I don't know if the court will be okay with that or not, but it's just clear to me that it's just, they give the warning and then it's done. You might fight about whether or not you're within 8 feet. You can still irritate an officer, but you got an 8 foot buffer. That's it. Peggy Terry became a YouTube member. Thank you, Peggy. Nigel 1701 became a YouTube member. Thank you, Nigel. That's awesome. Kathy Richardson, $2. Happy Saturday, Mike and Kurt. Oh, thank you, Kathy. Night and Knee, $1.99. Hit that like button, Nerd Herd. Yes. If anyone's left, thank you so much. I'm always impressed. I knew this would be serious and dry like this, but there are a bunch of you are here. I'm always nervous. I'm like, oh, it's not entertaining enough. But when I have stuff that's just more interesting. The other one, the one more recently, I couldn't believe everyone responded to it too. There was a hearing. It was just a extradition, and it wasn't like funny or anything like that. I'm just like, this is interesting. I've never seen that. I just want to do it for everybody was into the extradition hearing. It's really cool. My audience is awesome. April Searing became a YouTube member. Thank you, April. Oh, John O'Brien. John was just on with us. He super chatted. In New York, there's simply a ticket for speed not prudent under the conditions, which grants wide discretion. I'm going to try to drop in a few minutes. Well, thank you, John. You did drop in, and you were awesome. Night of Knee, $1.99. Kathy Richardson or untie if an ascot is born. I did get the fez out. I did not resort to the ascot tonight. Karen Conrad, $1.99. Treats for pups. Oh, thank you. Rudy Joe, $2. Get really cerebral for Mike's usual audience. Getting really cerebral for Mike's usual audience. Yes. Kathy Richardson. Mike, sounds like you need more ginger hot tea. Yeah, I was thinking that myself because I feel a lot better, but there's just a little lingering, and I actually just felt bad because because you guys have to hear it. But I mostly feel better, but I got some lingering stuff. Uzlumbird is a new member. Thank you. I don't know how Uzlumbird. I think that's it. That's pretty cool. Night of Knee, $4.99. Every new fact U3 give me makes my brain to storage capacity reach. Push out info from my brain like the ability to walk and chew gum simultaneously. Oh, all right. Let me see here. Let me make sure I didn't miss any here. Oh, it's just Judy. Mike's Nutty Adventure Fund. Got to keep it solvent. Yeah, seriously, and there have been no naughty adventures because I haven't been feeling right. At some point, there might have to be some. All right. Well, thank you all for coming out. That was fun, and I did warn you, but I think it was somewhat educational as well. All right. I will see you all soon. Thank you.